Okay. Is that okay?
Yeah, I think it's pretty much presentable for this PowerPoint. Yeah.
Mm-hmm.
Okay.
Yeah.
I believe everything is set up.
Mm-hmm.
So let's start. And I think we're having the guests join our meeting. Okay.
Mm-hmm.
Ladies and gentlemen, dear colleagues, good morning or good afternoon to you. And thank you so much for attending this web seminar held by Beijing Gaowo Law Firm. It is also our honor to have you here today. And this demonstration is going to be given by Nathan Chu, our outstanding patent attorney, who is located in Texas, US. And he has been in this industry for since the year of 2004, over 18 years, experience practicing in patent law. The main topic today is introduction of Chinese patent invalidation procedure and example cases. I hope through which you will have a further understanding of this procedure as well as all the related knowledges. Well, now I think Mr. Chu is ready to kick off. Mr. Chu, please take over the mic and start today's demonstration.
Okay. Yeah. Thanks, Mr. Zhang, for your opening words. Hello, everyone. Nice to meet you all over from the world. Welcome to my presentation. First of all, let me thank you for your taking time to be here today. It's my great honor and pleasure have you guys have this chance to briefly introduce the Chinese invalidation procedure. As you can see from on the screen, my presentation includes two parts. The first part, I just briefly introduce the Chinese patent invalidation procedure. The second part, I will introduce two example cases I used to handle with. Uh, okay. My name is Nathan Chu. I'm now living in Texas, America. So let me start by briefly introduce myself. I started my patent career since 2004 as a patent engineer, and I was registered as a patent attorney since 2009 before the Chinese Patent Office. I own a doctorate degree in power system and its automation. And the main clients I used to serve include the Sony Japan and the Sharp Japan, Schneider USA, and the Bayer medical manufacturer. The technical field I used to be involved in include the semiconductor manufacturing and display device. I also handle with some power system devices cases and also include some biosensors. These are the technical I used to get involved. In the past, I used to prosecute 625 Chinese invention applications and 58 utility models and 14 design applications before the Chinese Patent Office. Next, after my prosecution practice, I just dedicate myself to working on the patent litigation since 2015. Now, I just show you I have a small size family. This is my family picture. I have a son who is 15 years old. I also introduce my two very important family members. I have two cats. One is Migo, one is Pippin. They are very loved. Okay, So next, let's get started with my introduction of the Chinese patent invalidation procedure. So the Chinese patent invalidation procedure is basically an inter-party procedure. That means the procedure was between invalidation petitioner and the patentee. But although the Chinese invalidation procedure is an inter-party procedure, but the patentee is optional to take part into the procedure. But usually if the patentee doesn't take part into the procedure, the Chinese Patent Office, they will not try their best to defend your patent right. So if you are patentee, I strongly recommend you, the patentee, to take part into the procedure. So the procedure usually is inter-party procedure. So the office which in charge of the invalidation procedure is the re-examination and validation department of the patent office of the CNIPA. You know, the CNIPA is a short for the Chinese Intellectual Property Administration. So the agency used to handle with the invalidation request is named the Patent Re-examination Board. But now, since 2019, the Chinese Patent Office was reorganized. So now it's the re-examination and the invalidation department handling with the invalidation procedure. Okay, let's move on. So the first question is about who can file an invalidation procedure. In China, any entity or person is eligible to take part to submit invalidation request. But the person has the legal capacity for civil conduct. So that means the petitioner cannot be a child or someone who has mental illness. In most cases, the petitioner should be accused infringer. That is the person who was accused by the patentee. So in most cases, the petitioner is a potential infringer. So in some cases, the infringer don't want the patentee to know who filed the the invalidation request. The infringer can have a third party to file the invalidation request. The third party could be a straw man, but you cannot file an invalidation request anonymously. In some cases, in rare case, the patentee himself can also file invalidation request against his own patent, but it's not so often. But there is some requirements for the patentee to file a invalidation request. The requirements include it mandatory for all the patentee to take part into the invalidation request. Another requirement is that the patentee can only invalidate can file a partial invalidation against his own patent. He cannot invalidate all the claims. Another requirement is that the patentee can only use the publication as the evidence to invalidate his own patent. In more rare case, the examiner can also file a invalidation request, but it's not the most cases. Okay, let's move on. Okay, the next one is question is about when can a request for invalidation be filed. As we know, the Chinese patent the Chinese patent invalidation request can only be filed after a patent application was granted. Specifically, it can only be filed after the announcement of a patent being granted. Anytime in China, anytime after the announcement, you can file an invalidation request. Even you can also file you can file invalidation request against abandoned or expired patent. In some cases, usually the petitioner makes some mistake. They file a invalidation request based on application publication. In China, we usually have 18 months publication for a patent application. So you cannot file an invalidation request based on the application publication copy. You can only file a invalidation request based on a granted copy of a patent. So make sure not make such mistake. If you file a invalidation request based on a application publication, the request will not be accepted. I just want to compare with the U.S. practice. For the USPTO, there is a multiple post-grant invalidation procedure, such as the inter-party review and post-grant review. In China, the invalidation procedure is the only way you can invalidate a patent, a Chinese patent. That means the Chinese invalidation procedure is, I think it's very straightforward compared to that of the USPTO. For the USPTO, you can only file a RPR after 6 months since the grant date of a patent. You can only file a post-grant review within 9 months since the grant date. But in China, you don't care about that. You as long as you file the invalidation request after the announcement of a patent being granted. Okay, so next, let's move on to the third question. The third question is about where should a request for invalidation be filed? In China, you can only file an invalidation request before the re-examination in the invalidation department of the patent office of the CNIPA. It's not like the USPTO. In USPTO, you can the federal court has also the jurisdiction against to invalidate US patent. But in China, only the patent office had the jurisdiction to invalidate a Chinese patent. Okay, next, I'll just introduce what causes can be based on to file a request for invalidation. As we know, I just said that the Chinese patent invalidation procedure is the only way to invalidate a patent. So I think the Chinese invalidation procedure is very comprehensive. So the causes, there is a multiple causes to invalidate a Chinese patent. So you can file a patent invalidation request based on the novelty problem. This is most commonly used. You can also file obviousness based on the lacking of obviousness. This is the mostly used in most cases. The novelty reasons you can use, but in rare case, the two invention are totally the same. So in most cases, the obviousness reason is mostly used. You can also, based on the reason, that is the independent claim lacks essential feature. Based on the Chinese patent law, the independent claim has to include all the essential feature to achieve the purpose of the claim, to solve the technical problem of the independent claim, such as if the independent claim is a claim of the means plus function, you have to include all the technical features, all the means to achieve the function. So I think this reason can only be directed to an independent claim. Next, you can also file an invalidation request based on the claims are not supported by the description. So for this reason, it's no matter the claims is an independent claim or a dependent claim. This is, I think, this reason is also frequently used. Another one is the claim scope has to be clear, has to be definite. So if the claim scope is ambiguous, is indefinite, you can also invalidate claims based on the clarity problem. Next, you can also file invalidate a claim by arguing that the description incompletely disclose the technical solutions for technical solutions claimed by the claims. This is that is means you can also file on the based on the reason of the description fail to completely disclose. Today I will present the example cases I used to handle. You can see I will introduce in detail about this reason. Next, you can also, based on the reason, if the patent, during the prosecution of a patent, the patent applicant introduced some new matter by amendment, you can also file. You can also, based on this reason, to invalidate a patent. I think this principle is universal all over the world. Next, you can also file a based on the reason that is the claims claim the subject matter which is non-statutory, such as if you file a subject related to a scientific discovery, it's a non-statutory subject matter. I think this reason is not used frequently in many cases during the prosecution. I think this problem, in most cases, it has already been filtered out. As a USPTO, the Chinese patent can be also invalidated by double patenting. Next one, your patent application. Patent cannot violate the law, morality, and public interest, such as based on the Chinese law, you can the gambling tool is violates the law. So your the subject matter of your application cannot be a gambling tool. This are just to give you an example. So in summary, so I just let you know that the reason for invalidation request, the implementing regulations of the Chinese patent law list the reasons for invalidate a patent. So your reasons has to be one of the reasons listed in the implementing regulations. You cannot go beyond that. Specifically in China, you cannot file a invalidation request based on the lacking of the unity. So next one, you can also invalidate a patent based on the reason if the patentee file a foreign filing without a secret examination. This is the reason you can invalidate a patent. This is the same reason as the USPTO. Okay, so the fifth question is about when can the cause and evidence be submitted. You can file the cause and evidence on the date you file invalidation, or you can also supplement the causes and evidence within 1 month after the request is filed. I think the 1 month is the grace period by the patent office. But please bear in mind the 1 month is not extendable. I think that 1 month you can, if it's very urgent for the petitioner to file and prepare all the documents, you can use this 1 month grace period to supplement the causes and evidence. And also in some cases if you use the evidence in foreign language, you can file the translation of the foreign language evidence within one month. Usually the translation takes some time to be finished, so you can supplement the translation within 1 month after the request. But there is 2 exceptions. You can file the evidence and the causes after 1 month period. The first exceptions that you can file the evidence for common knowledge in the art until the end of the oral hearing. In this case, you can file such as the dictionary, manual, textbook, to demonstrate some technical feature belong to the common knowledge in the art. So you can present this during the procedure of the oral hearing. Another exception is that after you file your invalidation request, the petitioner usually file an answer to your request. So if the patentee amend the claims in response to your request by combination or present some counter evidence, you can also file some evidence and causes after 1 month period. This is the second exceptions. Okay, so next, I just present the question 6. What evidence can be submitted? In China, the evidence are also comprehensive. You can present any pro arts, including the patent. It could be a patent all over the world. No matter it's in China, it's a Chinese patent, a US patent, European patent. You can use the patent all over the world as your evidence. You can also use a printed publication as your evidence, such as a paper, such as some other printed publication. It can be also a book. You can also use a prior use evidence to invalidate a patent or price sale. You can also use any other publication before the filing date, such as a web, internet publication. You can also use evidence such as the oral lecture, something like that. So I think the evidence is more comprehensive. As long as you can invalidate, you believe you can invalidate a patent. Next, how does the invalidation procedure conduct? This is a flow chart for the. This is it's a fundamental flow chart for the invalidation procedure. So the first step is the petitioner has to file a request for invalidation initially. That means the petitioner has to kick off the match. When you file the request, the patent office will conduct a formality examination on the request. The formality examination include they will check whether you have filed all the required documents for the request, whether you have paid the fee for the invalidation request. They will also check whether your request is based on a granted patent. They also check the eligibility of the petitioner. They'll also check the power of attorney between the petitioner and the attorney. If the office finds some formality issue, they will issue a formality notification to the petitioner. The notification usually have some new include the new notification of remedy. If the formality issue can be solved, can be corrected, they will issue a notification remedy to let the petitioner to correct some formality issue. In some cases, if you don't pay the invalidation fee or you don't fully pay the fee, the patent office will issue a notification of being deemed not to file. In some cases, in your request, you fail to present the causes, or even in some cases, you present the causes for the invalidation, you fail to figure out the combination of the evidence, they will issue a notification of non-acceptance. You have to refile, you have to resubmit your request. If the request doesn't have any formality issue, the patent office, the department will issue acceptance notification acceptance to the petitioner. Meanwhile, they will also forward the acceptance of invalidation request to the patentee. When the patentee receive, meanwhile, the patent office will also forward a copy of all the documents for the of the invalidation procedure to the patentee. When the patentee receive all the documents and the acceptance of the notification of acceptance, the patentee can optionally file an answer to the patent office. That means it's not mandatory, it's not necessary for the patentee to file answer. So my suggestion is that if the patentee don't want the patent petitioner to know your own arguments, your own starting points, you can only file some formality documents, such as you can only file a power of attorney to the patent office without presenting your comments in response to the invalidation request. This is my suggestion. Such as, I think the match is just like playing cards. In some cases, you have to hide your own card. This is a strategy to the patentee. So when the patent the department received the patentee answer, they usually also take some formality examination on the patentee's answer. But I think the formality examination to the patentee answer is usually very simple. They usually just check some the formality on power of attorney. I think it's very simple. After that, the department will have usually will have 3 panelists to form a panel to conduct a collision.
Hello, Mr. Chu. Can you actually hear me now? Okay, ladies and gentlemen, thank you so much for joining the meeting. I see we are having some malfunction in this team web seminar. Please hold on a second. We will have
Okay.
Mr. Chu coming back again.
Okay, what happens? I think the line was disconnected just now.
I can hear you vividly. And Mr. Chu, would you please, would you mind return on the PPT and keep on the demonstration?
Okay, I'm not sure where we were right now. I'm not sure. Let me.
I think we were stopping at the seventh agenda. You can turn it back off like 5 minutes with the contents you mentioned before. Yeah.
Okay, so please tell me, let me know where we were just now.
Is there any malfunction with the microphone in your side? Because this time I'm not hearing you vividly as moments ago.
You mean the voice is very low?
Exactly.
Okay. Let me check what happens. Can you hear me well?
I can hear you now, but not as well as before.
Oh, sorry. I think I have turned. I think I have turned the volume of a speaker to the most.
Okay, so Mr. Chu, please go ahead.
Okay.
Yeah.
Is it okay?
Yes.
Okay. Okay. Let me restart from the procedure. Okay.
Okay.
Right here. Okay. Can you
Okay,
see
sure.
the screen I share?
Yeah, we're having it on the screen.
Okay. Okay. So uh so after the collegiate examination, the panel will check the scope. That is, they will check the scope means whether the petitioner intend to invalidate all the claims or some of the claims. They will also check the causes. They will also check the evidence. After the collegiate examination, they will issue a notification of the oral hearing to both parties. The oral hearing generally will be conducted during the invalidation procedure. Uh, as we know, the patentee can be absent for the oral hearing, but as I said, usually the patentee should be present in the oral hearing. If the patent you don't try your best to defend your patent, the patent office, they will not try their best. So after the hearing, the department will examine the arguments between the two parties. Then we'll issue an invalidation decision. When the both party receive the invalidation decision, if if they disagree with the decision, they can file appeal to the Beijing IP Court, Intellectual Property Court, where the Chinese Patent Office is located. Okay, let's move on. Okay, next I'll just present the amendments, talk about amendments during the invalidation procedure. I think for the Chinese invalidation procedure, I think the amendment is very strict. First, I just let you know some general principle for amending. The first is that you cannot change the subject matter of the claims. That means you cannot change a method claim to a device claim. You cannot change from the chair to a desk. This is a requirement. The second one is that I think it should be universal around the world. You cannot broaden the original claim scope. That means you can only narrow down or keep the same as the original claim scope. The third principle is that your amendment cannot go beyond the original disclosure. I think it's also universal all over the world. The fourth one is that you're usually not allowed to any feature not residing in the granted claims. That means you can incorporate some features in the granted claims, but usually you cannot incorporate some features from the description. Usually it's not allowed, except for some amendments is very, very obvious to a ordinary skilled person in the art. It should be obvious errors. Then I just present several specific manner for claim amending. During the invalidation procedure, the patentee can delete one or more claims. It's allowed. In some Marcuse claim, there used to be some alternative technical solution. You can delete one or some of them, such as A or B or C. You can delete some of them. The third one, you can add. It's allowed. It's allowed. You can also correct some obvious errors, but the errors should be obvious to the skilled person in the art. You can see the amendment requirements is very strict for the Chinese patent invalidation procedure. Normally, you can only amend the claims within the scope of the claims. So next, I just introduce the invalidation decision by the department. The decision maybe the claims was entirely invalidated by the department. All the claims were invalidated. In some cases, maybe some of the claims were invalidated, partially invalidated. In some cases, maybe the department reject the request by the petitioner. They also maintain the validity of a patent, a Chinese patent. So next, if you disagree, both party, either of the party disagree with the invalidation decision, you can file appeal. You can appeal the invalidation decision before the Beijing IP court within 3 months from the date of the receipt of the decision. Please bear in mind, it's the date is from the date of receipt of the decision. Okay, so I have finished the introduction of the invalidation procedure. So now let's take a break. I just give my floor to Mr. Zhang.
Okay, ladies and gentlemen, and how do you think about this first part of the lecture given by Mr. Chu? We wish you have gained a better understanding of the procedure of filing patent invalidation, its legal basis, and examination procedures, and so on. Well, like Mr. Chu has mentioned, I think it's time to have a halftime break here. So please feel free to have a refresh, and let's come back in 5 minutes. Then we should move to the second agenda, introduction of example cases, which we believe is also productive and interesting. You may have missed a little bit about the contents today, but the second agenda is also very inviting. We hope you could be still staying with us. So we will see you in 5 minutes.
Hi, Mr. Zhang, do you think the voice is okay?
I think it's very much recovered, and everybody aside, despite of me, everybody's saying they hear you well.
Okay. If you think has any technical problem, please feel free to let me know anytime.
Okay. Well, I think now everybody is pretty much set up, and feel free to go on the second agenda when you are ready, Mr. Chu.
Okay. Okay.
Well, okay, Mr. Chu, I think the halftime break is over. And how about we go back and start the second half of the game?
Okay, sure. Okay.
Yeah.
So let's go ahead. Mhm. Okay, hello everyone. Welcome back to be back, and let's get started our second half of the game. So next, I just introduce two real cases I used to handle with. I think it's very interesting. Uh, so the first example case is about a massaging device and a four-arm massaging machine. This invalidation case is against invention patent. As you know, in China, we have three kinds of patent. One is invention, another one is utility model, another one is design. So uh, in these three kinds of patent, I think the utility model is the patent which was challenged by the invalidation request. Because as you know, in China, the utility model doesn't have the substantial examination. The patent office only conduct some formality examination uh, with respect to the utility model. So I suppose in China, in most cases, the invalidation request is against a utility model. Yeah, but this case is about an invention. Yeah, uh, the patentee of the invention is by a Japanese massaging manufacturer company. The name of the patentee is Hajime Midori. Uh, the invalidation petitioner is Xiaohong Shu. Actually, the petitioner is a competitor in China to the patentee, to the Japanese massaging device manufacturer, but the Chinese petitioner don't file the request in the name of the company, under the name of the company. They just use a natural person under the name of the natural person to file the request. I think this is a strategy. In some cases, the petitioner don't want the patentee to know who filed the request against their patent. Let's move on. Okay, so next I just tell you that the invention include 10 claims. So the patentee, the scope of the request just intend to invalidate all the claims, all the claims. The evidence submitted on the date of filing the request file the evidence number 1 to number 10, number 8. Within the 1 month period, the petitioner submitted the evidence number 9 to number 12. Yeah, so I think in some cases, I'm just on behalf of the petitioner. Yeah, so I think on the oral hearing, when you argue with the patentee, in some cases you can withdraw some evidence depending on the on the oral hearing, depends on the comments of the opposite party. You can withdraw some weak evidences. So on the oral hearing, I just withdrew the evidence number 3 to 6 and 8. Okay, so next, on the date of filing the request, I just submit the causes. That is the claims 1, 5, 4, and 8, lacking of the novelty. But these causes I just withdraw on the oral hearing. So I also file the causes claims 1 to 10, lacking of non-obviousness. So on for the claim 1, I also file file causes of lacking essential feature for the claim 1, but this causes has also been withdrawn on the oral hearing. I just want to my strategy is that when you file a request, you should prepare a multiple reasons to invalidate a patent. Because in most cases you are not sure which cases works effectively. So I think some of the cases could be a backup reason. Of course, you can use one or two reasons and strong evidence, strong reason. You can invalidate patent. But my strategy is, as a petitioner, I will usually file multiple reasons. For the claims 1788, I just file reason, that is the claim scope is not clear, is not a have some clarity problem. So this reason was also withdrawn on the oral hearing. So within the 1 month period, I just supplement some causes, that is the claim 8 and the 10 being not supported by the description. So within the 1 month, I have plenty of time to take a look, to investigate some details of the patent. So I just found the claims 8 and the 10 cannot be supported by the description. So I think this reason is very, very strong. Is very, very strong. So I think this is a very good reason to invalidate some claims, because by using this reason, you it's not necessary for you to provide any evidence. I think it's very easy and very straightforward, but it works very effectively. So during the 1 month period, I also supplement reason, that is like claim 1, lacking of non-obviousness based on some new combinations of the evidence. I just use 3 combinations of the evidence to invalidate claim 1. That is, I just use evidence number 1 plus 9, evidence 1 plus evidence 11, evidence 1 plus evidence 7. Yeah, for the claims 2 and 10, dependent claims 2 and 10 are just also use further evidence to combine with the evidence for the claim 1. Okay, next I'll just introduce the how the invention works, introduce the technical solution of the claim 1. The claim 1 is directed, the subject of the claim 1 is direct to a chair type massage device. You can see the picture on the right bottom. I think it's very commonly seen. Yeah, it's a very popular device, massage device. I just highlight in red the some key, some essential, some very important technical feature for the claim 1. So the chair type massage device include an armrest numbered 33. You can see the left and the right have an armrest. So the also include a forearm massager. You can see on the picture, which is number 7. Number 7 right here. You can see a forearm massager, which is used to massage the forearm. Next important technical feature is that the claim 1 recite that the forearm massager is shorter than the length of the armrest. That means you can see apparently from the picture, you can see that the forearm massager number 7 is shorter than the forearm, is shorter than the armrest 33. Another technical feature is that the forearm massager can be movable along in the longitude direction of the armrest. You can see from the picture the forearm massager can be moved along the armrest. I believe it's very apparent. Yeah, this is the scope of the claim 1. Okay, let's go on. Okay, so the first I just introduce the combination 1 I used to invalidate the claim 1 based on the reason of lacking of non-obviousness. As you know, based on the Chinese patent practice for the obviousness rejection, we usually have to figure out closest prior art which discloses the majority of the technical features of the independent claims. I just use evidence 1 as the closest prior art. I think this evidence disclose the majority of the features. You can see from the evidence 1, you can see it's also a chair type massage device. From the picture, you can also see there is a armrest named number 25. Number 25. It's also an armrest. It should be 24 is a number rest. Then 25 is the forearm massager, which can massage, clamp the forearm and massage the forearm. So I think the difference between them is that the evidence one doesn't disclose the forearm massager is shorter than armrest, and also fail to disclose the massager is movable along the longitude direction of the armrest. I just introduce another evidence, evidence 11, to combine with the closest prior art. From the evidence, you can see that it's also a chair type massage device. The massage device also include armrest number 2. You can also see that on the armrest, there also a forearm massager number 23. Number 23. The number 23 include two massage part, number 26 and the number 27. I just argue that the number 23, the massager is shorter than the armrest 2. And from the picture, another picture of the evidence 11 on the right, you can see when the back of the chair inclined backward, there is a rope number 37. Drag the armrest to slide along the longitude of the armrest number 2. So it means the massager, the forearm massager 23 is also slidable, is also movable along the longitude direction of the armrest. So I think the combination of the claim 1, a combination of the evidence 1 and evidence 11 can reject the claim 1. So I just think this is the strongest combination evidence I used to invalidate claim 1. I just tell you that the arguments between the petitioner and the debating between the petitioner and the patentee. On the oral hearing, the patentee argue that in the evidence 11, the patentee think the movement of the the massager, forearm massager 23 is the purpose of the configuration is to keep the massaging position of the arm stable and fixed when the back inclined back forward, and he think the purpose of the his invention is just to change the massaging position of the forearm by moving the massager. For this argument, I just present opposite arguments. Actually, I just show you the description of the challenged claim 1, challenged patent. In the challenged patent, in the description on the page 4 and the paragraph 3, it has already disclosed that by changing the reclining angle of the back, even when the position of the forearm of the person to be treated as a positional deviation with respect to the armrest, it's possible to change the movement of the massager according to the deviation. Thereby, I just highlight some key points. Maintaining the relative positional relationship between the forearm and the forearm massager. That is, you can see from the description, the patentee has already disclosed that the movement of the massager is not necessary to change the massage position of the forearm. It also can, for the purpose of keeping the massaging position fixed. So I think it's his own disclosure not specify the purpose of the movement. So I think I just argue with this evidence based on this standing point. Okay, so next I just present another combination of the evidence for the lacking of non-obviousness. For the second combination, I still use the same closest prior art evidence 1, and I use another evidence 9, which is a US patent. From the picture, you can see that there is a roller number 28, which can be also movable along the arm. This is another picture of the on the right is a detailed illustration of the forearm massager. For these combinations, I think the combination of them can challenge the claim 1, but the patentee think that he just told that difference between them is that the evidence 9, the roller can only massage the forearm by moving along the direction of the arm. You can see from the picture when the roller just roll and it will massage the forearm. So he think the configuration, the working principle is different from the claim 1, but I think in the I argue that in claim 1 it does not specify the movement of the forearm massager. It can be also slidable. It can be movable to massage the forearm. So I think the purpose is not specified in the claim 1 as well in the description. This is my observation. Okay, next I just introduce another combination 3. I just use another evidence 7 to combine with the evidence 1 to challenge claim 1. The evidence 7 disclosed a massager for the leg. You can see from the figure on the right bottom. You can see this is a leg. This is a massager for the leg. The number 45. number 45 can be placed on this plate. Number 130, the 130 can be also slidable along the bar 101. So it can be also change. It can be also movable along with the bar. So I think it's very obvious is to the skilled person in the art to use to change the massager, the leg massager to the forearm massager. I think just combine with the common knowledge in the art to challenge the claim 1. But the patent team think that it's very difficult, it's very hard for the skilled person in the art to combine a leg massager, because the leg and the forearm has different configuration, different shape. So he think the massager should have different configuration. This is his point. But I think I just argue that it's very apparent for the skilled person to transfer to utilize the leg massager. It's apparent substitution. Okay, after I introduce the reason of lacking of obviousness, I just introduce another reason. I challenge claim 1. I just want to tell you, challenge the claim 8 and 10 by lacking support by the description. First, I just introduce some details of about the challenged invention. In the description of the invention, on the page 18 and the paragraph 2, these two pictures just illustrate the detailed cross-section view of the forearm massager. I'll just go back to the picture. You can see the number 7. Number 7. This is a forearm massager. So these two pictures are the detailed and the enlarged view of the arm massager. You can it's a section. It's a sectional view. You can see from the picture that there is a supporting part, number 48. So your arm just at the circle indicates this is the arm of the forearm of the user of the device. Just to put your arm in between the supporting part 48 and also a clamping part number 47. So the two parts clamp the forearm of the user. So there is another part which is airbag number 50. So when the airbag was inflated by air, the airbag will expand. It will push forward the number 47, approach the supporting portion number 48. So it will clamp the forearm. But after the approaching, when you want the 47 to move away from the 48, the description disclose that there is a urging means such as a spring not shown in the picture is provided in the vicinity of the rotating shaft 45D. There is a urging means such as a spring to push the holding portion 47 away from the fixed support portion 46 in the direction away from it. So you can see in the description, it clearly disclosed that there should be a spring to move the part number 47 away from the part number 46. It has to be provided. Such this is just the status when the holding portion is away from the fixed portion is indicated in the left picture. You can see that. Yeah, next. I'll just show you that in the claim 7, claim 7 just indicate that the forearm massager include an actuator capable of moving in direction of approaching and moving away from the fixed support portion. So claim 7 just limit claim actuator which can be moving close and away from the fixed support portion. But in claim 8, which depends on claim 7, it just indicates the actuator is an airbag. So I think in the claim 8, it only recite the actuator is an airbag. But from the description, we can see that the actuator has to work with the spring when both of them move away from each other. So the spring is necessary. If the actuator doesn't include a spring, it will not work. So I just found this weakness of the claim 8. So I just challenge the claim 8 based on the reason of lacking support from the description. I think the actuator has to include another important part, which could be a spring. Spring has to be included as the description discloses. Okay, I'll just tell you the final invalidation decision. So finally, the department just invalidate the claims 8 and 10 was invalidated as lacking of support by the description because the claim 8, 10 is dependent on the claim 8. So both of them can be invalidated based on the reason, the same reason. I think it's a very strong reason to invalidate claim 10, 8 and 10 because for the department, for the panelist, they don't need to use evidence to challenge the claim 8 and 10. So I think it's also easy for them to invalidate the dependent claims 8 and 10. So finally, the examiner, the panel also invalidated the other claims 1 to 7 and 10 as lacking of non-obviousness by adopting my combination of evidence 1 plus evidence 11. Finally. Okay. Yeah, as you can see, my strategy is that we usually, when we file a invalidation request, we should provide as much as possible more evidence, more reasons, in which we should include some strong evidence, the reasons only by which the department, the panel, can choose some of them to invalidate a patent. Okay, so let's move on to the next example case. Example case 2. I think this case is about a utility model of Chinese patent. I think it's very easy to understand. So this utility model is about a high-strength gardening pillar used now as for some plants with vine. There should use some the pillar. The pillar is used to support the vine of some plants, such as the grape. So the patentee of the utility model is a Chinese gardening supplies company, and the petitioner is also a Chinese competitor located in Changzhou, China. Okay, the utility model includes 5 claims altogether. I just highlight some key points, key feature for you to read. Okay, so as seen from the picture, the claim 1 is directed to the high-strength gardening pillar. It includes a metal tube number 1. Metal tube number 1. The 2 ends of the metal tube 1 are tapered shape as seen from the picture. That means the diameter of the 2 ends decreased progressively until to the ends of the tube, as you can see from the number from the picture. The claim 1 also include the 2 caps to cover the 2 ends of the metal tube. The 2 ends are 2 cap are number 3 and number 4. The claim 1 also includes some other parts, which is the number 2 is a plastic layer. Also include 21. There is some rib axle is arranging along the metal tube. I think these 2 parts are just to facilitate the vine of the client to be attached on the metal tube. Okay, so in the claim 4, the claim 4 further limit the taper shaped of the metal tube is shaped as truncated cone. You can see from the picture, the 2 ends of the metal tube is not a complete cone. The top of the cone was truncated, the 2 ends. And in the claim 5, it also further limit the shape of the bar cap. Number 3 and number 4, it said that the shape of the cap can be tip shaped or flat top shaped. flat top. You can see this cap is flatter, is flat top shaped, and this one is tip shaped, tip shaped. Okay. Okay, let's move on. Okay, I just the scope of my invalidation is invalidate all the claims, the number 1 to number 5. Evidence on the date of filing the request, I just submit evidence 1 and 2. Within the 1 month grace period, I just supplement evidence 3 to 5. Regarding the causes, the reasons on filing the request, I just invalidate, challenge the claims 1 to 5 as lacking of non-obviousness based on the combination of evidence 1 plus evidence 2. Within 1 month, I just supplement further reasons, further causes, is the description incomplete disclosure. I just challenge the invention by the description, incompletely disclosure. For the claims 1 to 5, I raise up another reason, that is the claims 1 to 5 cannot be supported by the description, in which the causes for the claim 4 was withdrawn on the oral hearing, and for the claims 1 to 5, I also use the reason of lacking of non-obviousness. Actually, during the on the final decision, the panel rejected the first 2 reasons and support the final reasons of lacking of non-obviousness. Okay. This is my evidence combinations. I provide multiple combinations of evidence. First, I just plus evidence 1 plus common knowledge, evidence 1 plus evidence 2, evidence 1 plus evidence 5. So I just provide multiple evidence combinations. Okay, so next, I just introduce the debating between myself and the patentee. I just introduce some key points of the debating. First, I just tell you that one reason is that I invalidate the invention, the utility model, by incomplete of the disclosure of the description. In the description of the utility model, the applicant figure out the object of the invention is to prevent the cap from being broken. The cap, as you can see from the picture, the cap of the metal tube. You can the cap 3 and cap 4. Yeah, I just argue that the description disclose the objection of the invention is to prevent the cam from being broken, but the description is still the 2 ends of the metal tube is tapered shaped. That is the technical solution claimed by the claim 1 is the 2 ends of the metal tube is tapered shape. So just to argue that the taper-shaped ends of the metal tube has nothing to do with the objection of the invention. So this is my point. This is my point. So, so the description failed to completely disclose the technical solution which can achieve the object of the invention. The patentee think that if the two ends of the metal tube is strengthened, it can be it can prevent the cap from being broken naturally. So finally, the panel support the patentee's argument regarding this viewpoint. Okay, let's move on to the next reason. The next reason I raised up is put forward is that the claims 1, 3, 2, 3, and 5 not supported by the description. I think I just argue that the claims 1, 3, 2, 3, and 5 are too broad in scope with tapered shape. Specifically, I just show you that. Let's go back to the picture so it's easy for you guys to understand what I'm saying. Okay, so as you can see from the claim 1, just recite the two ends of the metal tube. The metal tube is tapered shape. So I believe that the tapered shape include all the shapes, not necessary as shown in the picture. It can be a truncated cone. It could be also a tipped shape. It also can be like a spear shaped. So I think when the one of the ends of the metal tube is like a spear shaped, when the cap was put on the two ends, either of the ends, when you hammer the metal tube in the soil, in the earth, I think it's very easy for the cap to be broken. So so I think you can make sense. So the hammer, so the pillar used to be a hammered in the soil, to support the vine. So I think the scope of the claim 1 with a tapered shape is too broad. So one embodiment, if the end is in spear shape, is tip shape, it cannot achieve the object of the invention. So I think it's too broad. Okay, let's see how the patentee opposite my arguments. The patentee think that the tapered shape encompass truncated is equivalent shape. He think that the truncated cone in the claim 1 should exclude the shape, or exclude the shape, the spear shape, the tip shape, which cannot solve the technical problem of the claim 1. So I think the panel just support the viewpoints of the patentee. The panel think that the tapered shape exclude the cone shape, which cannot solve the technical problem of the invention. Okay, so next, let's move on to the next reason. That is the claim one, lacking of the non-obviousness. I just use the evidence one as the closest prior art. From the picture, you can see that this evidence also include a metal tube number one, and also include the plastic layer number 1-4. It also include two caps, which number 2 and the number 3. You can see but uh, but the two ends of the metal tube in the evidence one, both of them are flat top. Flat top. They are not tapered shaped. They are not taper shaped. But I use another evidence two to combine with the evidence one to challenge claim one. In the evidence two, you can see the ends of the part, the metal tube one, is also tapered shaped. Is also tapered shaped. So I use the combination to challenge the event obviousness of the claim one. Claim one. Okay, so because we don't have too much time to tell some more details of the reason, so I just introduce one of the combinations. Actually, I also present the other evidence combinations, multiple of them. So because we don't have too much time, and it's very complicated. So I just introduce some main points of my debating the arguments, the procedure of this case. Uh, so finally, the panel just invalidate the claims 1-5 by adopting my reason of lacking of non-obviousness. The panel just use evidence one combined with a common knowledge in the art. This is the final decision. So this is the end of the my introduction of the Chinese patent invalidation procedure, as well as two real cases. I'm trying to clarify, try to clearly make you understand. So I think generally, I think the Chinese patent procedure is straightforward and comprehensive. Um, so finally, I just briefly introduce the general procedure for the patent attorney of Gaowo law firm when we on the procedure of the invalidation request. So usually we just the first steps when the client decide to entrust us to file a patent request, or the patentee entrust us to defend his patent. We usually sign a contract, sign a power of attorney. Then we initiate the procedure. The second step is we usually do the evidence to do the searching, evidence searching. I think this is a very important step for the invalidation request. I think the strong evidence plays a very important role for you to win the match. Uh, then we usually, if we have some foreign language evidence, we usually need to translate the evidence. Uh, then the lawyer, the patent, prepare all the documents, uh, the substantial documents, the invalidation brief, and the arguments, as well as some formality documents such as the power of attorney, the request form, something like that. Then we file the patent invalidation request before the panel, before the department. Then when we receive the notification of the oral hearing, our attorney need to take part into attend the oral hearing and argue with the other party. After the oral hearing, we usually receive a decision from the department. Further, if either of the party disagree with the decision, we usually can file appeal before the Beijing IP court to sue the department, to sue the Chinese Patent Office against their decision. This is my brief introduction of our procedure when we accept invalidation from request from the party, from the patentee or the petitioner. Okay, that's the end of my presentation. If you guys have any questions, you can reach out to your counselor or the advisor in the GAOWO law firm and reach out to me. Finally, I just say thank you to you all guys. Okay, I just give my floor to the host, Mr. Zhang. Mm-hmm.
Okay, dear colleagues, I think Mr. Chu has finished his webinar today, safe and sound. Mr. Chu, I would like to thank you so much for the complete preparation and your decent demonstration for today. It was indeed very tough. Also, we believe it is a wonderful presentation. We also highly appreciate that you took time to join us. Thank you for staying with us. The GAOWO team is always standing by for any possible assistance for you here in China. And please do not hesitate to contact a key person in our firm. And we are more than joyful to offer our help and legal advices on issues aside from prosecution works. We sincerely look forward to furthering the cooperations with you. Last but not least, thank you so much for your attention and listening. We will see you next time. Bye-bye.
See you. Bye-bye.
Bye-bye.
Bye-bye.